Here unfolds one of the world's most influential, and at the same time most easily manipulated legal systems, the Anglo-Saxon Common Law, a system that shapes the lives of more than 2.5 billion people, intertwined with global economics, politics, international contracts, and the hidden mechanisms of judicial influence. Its principles quietly infiltrate everyday life. How disputes are settled on the street, in the workplace, and especially in the courtroom, where the emotions of jurors often outweigh the facts. This is not just a set of rules, it is a living, flexible, politically sensitive logic of justice, allowing the meaning of the law to shift through precedent and interpretation. We will travel through time, from the royal courts of the 11th century to modern Supreme Courts in the United States and Singapore, and we will understand why common law became a global standard of flexibility and legal logic. The birth of common law. 1066, the Norman Conquest. William the Conqueror creates a centralized royal judiciary. Judges travel across England, issuing consistent decisions for all regions. This is how common law is born, the shared law of the entire kingdom. 12th to 13th centuries, the rise of precedent. Judges begin recording rulings. The foundational principle emerges, stare decisis, to stand by what has been decided. From now on, judicial rulings become a primary source of law. 15th century, equity emerges in parallel. When the common law fails to provide a solution, the chancellor intervenes. He introduces injunctions, specific performance, compulsory performance, equitable remedies, flexible remedies. 19th century, merger of systems. The Judicature Acts, 1873 to 1875, unify common law and equity. A modern judge can apply both sets of principles in a single case. What makes common law unique? Judicial precedent is the core of the system. Decisions of higher courts bind all lower courts, ensuring consistency, stability, and predictable justice. The active role of the judge. Judges do not merely interpret the law, they actively shape and create it through their decisions, influencing legal norms and future rulings. Adversarial trial system. The parties compete in a structured legal battle. The judge acts as an impartial arbiter, not an investigator. Cross-examinations, strict evidence rules, and procedural fairness stand at the core. Flexibility and evolution. Common law evolves case by case, continually adapting to society's changing needs. Common law across the world. Structure, magistrates, Crown Court, High Court, Court of Appeal. Unique feature, there is no single written constitution. Opinion, justice influenced by the judge's personal views, character, and mood. The possibility of manipulating precedents created in different centuries, eras, and circumstances. A wide field for interpretations and potential manipulation. United States federal model. Structure, federal courts and separate state court systems. U.S. Supreme Court decisions shape national rights and freedoms. Strong tradition of trial by jury. Opinion, justice bends to judges' politics. Old precedents enable manipulation. State climates sway courts, and juries often decide by emotion over expertise. Canada. 9 provinces use common law. Quebec uses civil law. The Supreme Court bridges both traditions. Australia. Strict hierarchy of precedent. High Court of Australia sets national standards. India. British legacy and powerful constitutional law. Supreme Court highly active in rights protection. Singapore. Modernized, highly efficient common law. Emphasis on clarity, economic stability, and judicial discipline. South Africa. Hybrid system, Roman Dutch and common law. Strong constitutional oversight. Why common law became the global standard? The British Empire. Common law did not spread across the world because of universal values. It became global because it traveled with British ships, trading posts, and regiments. Wherever the empire established order, common law followed. Economic efficiency. Common law became the foundation of global markets not because it is perfect, but because it works faster, more predictably, and at a lower cost for business. Efficiency, clarity, and contractual discipline made it the preferred system for commerce. International commercial law. Business does not tolerate ideology. Common law became the language of international trade because it provides clear contracts and resolves disputes through strict judicial procedures rather than emotion or political pressure. Reputation for predictability. Common law became a standard because it is built to respect its own structure. Higher courts set binding precedents, and lower courts follow them. This internal discipline creates legal stability. Evolutionary adaptability. Common law changes slowly, step by step. It is not a revolution, not another progressive reform that breaks everything overnight, as happens in some constitutional systems. It evolves naturally, preserving continuity instead of destroying it. Today, common law is no longer just a legal system. It is a mindset, one that can defend freedom, yet quietly reshape the rules whenever it serves those who know how to bend precedent. In theory, it stands for fact-based reasoning, individual judgment, and protection from state overreach. In practice, it often becomes a stage where skilled lawyers manipulate juries through emotion, and judges reinterpret old rulings to produce modern political outcomes. A system that claims independence can easily drift into subtle influence. Judges whose decisions shape national policy. Attorneys who sway jurors with theatrics. Precedents selected not for truth, but for ideological convenience. No need for elections, no need for public debate. One creative ruling can shift the meaning of the law overnight. Yes, the world changes and common law changes with it, but not always for the sake of liberty. It evolves in favor of those who control its flexibility. Quietly, incrementally, precedent by precedent, under the banner of legal development. And a skeptic sees it clearly, where the law can be bent by jury emotions and politically charged interpretations. Freedom lasts only as long as those in power allow it. Common law versus civil law. Source of law, precedents versus codes. Common law relies on judicial precedents, giving flexibility but inviting political manipulation. Civil law fixes rules and codes, yet lawmakers can rewrite them. In both systems, the source of law remains vulnerable to influence. Judge. Creates versus applies. In common law, judges effectively shape the law, influencing politics without elections. In civil law, they apply norms, but vague statutes allow broad interpretation. In both models, judges can steer outcomes subtly. Process. Adversarial versus investigative. The adversarial system favors wealth. Stronger lawyers win. The investigative civil law model reduces this bias but expands judicial power. Both processes risk hidden imbalances and strategic manipulation. Flexibility. High versus low. Common law adapts quickly but enables ideological shifts through precedent. Civil law is stable yet slow to respond. Both systems balance between needed flexibility and protection from political interference. Constitution. Absent versus present. Common law countries may lack a single constitution, easing silent rule changes. Civil law systems rely on written constitutions, but they too can be amended. Stability in both models depends on political restraint.